Article 39 Clause C is one of the most pivotal provision of our Indian Constitution, and which is the topic of discussion today. Article 39C is a kind of directive principles of state policy as enshrined in our Indian Constitution. What is its objects and what are the principal problems and what are the principal or probable solutions of those problems or challenges? That is the subject matter of discussion today. Article 39 of Indian Constitution states that certain principles of state policy is to be followed by the state. That means state must try to achieve some objectives, that is the directive principles of state policy. And 39 clause C says that the operation of the economic system the state must try to achieve, so that there must not be the concentration of the wealth and there must not be a detriment of the common interest. That means it says that the operation of the economic system does not result in the concentration of the wealth and means of production to the common detriment. So two things are most important over here. That is, the operation of economic system does not result in the concentration of the wealth, and another is that means of production to the common detriment. So state must try to achieve that end as per Article 39C, that operation of economic system does not result in concentration of wealth and means of production to the common detriment. We are aware that our constitution etymologically prescribes about equality amongst the citizens, and 39C is an end. That means one of the objectives is Article 39C achievement. But what is the actual criteria? Means what is our economic policy? We are everywhere, means it can be seen. We are aware that there is the creation of binaries. We know that there are public sector jobs and private sector job. Public sector and government sector job in one hand, and on the other hand we are getting the private sector jobs. And we know that there are huge differences between the scope among the employees of these two sectors. So by this binary creation, the question on the principal challenge which can be raised, that how the purpose of Article 39C can be achieved. It is like an absurd scenario, because whereas Article 39C says that there must not be concentration of wealth for the elite class of the people, or there must not be detrimental economy for the common interest, but there is the binary created by the state even after achievement of the independence, and that difference or wealth, the binaries are increasing day by day. The wealth are becoming or gaining too much wealth. That means the rich persons are increasing their wealth, whereas the poor remains too much poor. That means the binary what is created already because of this scope of government or public sector job and as well as the private sector job, that is the principal challenge of achievement of Article 39 Clause C. Now I would like to discuss about the various reasons regarding this aspect. First of all, I would like to come about the difference fee structure, that means differences in salary between the private sector and public sector or government sector. In most of the cases, the salary difference is huge in comparison between government sector or public sector employee and the private sector employee. Means in most cases, in case of even the job is lenient, but the salary is fabulous. Apart from the salary, there is much other scope which is available to them, like pension, bonus, gratuity, provident fund, dearness allowances, and in various cases the public sector employee or government sector employee are getting the chance of free medical treatment, and also in some cases the special discount on various commodities. Whereas in case of private sector employee, they are doing the backpacking drudgery for only a mere pittance for their survival. And there is the fanfare, means declaration of the measly hike by the employer. That means if there is a very little hike of the salary, it is declared by the very pompous manner by the employer. Whereas in case of public sector employee, there is the regular hike of the salary. There is a proper security over there, job security, which is not available in case of the private sector employee, though the worker or employee is too much competent enough, but there is the lack of security. So that is the main challenge of Article 39C. So what is written there? That massive difference between salaries, working hours and job loads, and other enormous facilities like pension, gratuity, provident fund, dearness allowances, medical allowances, house rent allowances, regular increments, special discount in some cases of various commodities, as well as free medical treatment. So these scopes are available for comparatively lenient work in case of the public employee, whereas in case of private employee, these are completely absent. So this is a principal challenge, what I think, in case of application of Article 39C. Now I am coming to the next reason. Thirdly, I would like to discuss about the scope of negligence or avoidance of discharging the official duty. We know it is like a tradition that in government sector or public sector job workers, employees, on any pretext, irrational pretext, there is a tendency to shirk the official responsibility, like the ground of bandh, strike, hartal, or any other various reasons, and as a result public suffered a lot. Whereas in case of the private sector, there is no such chance of avoidance of the duty or responsibility. There is much more scope of getting the leave without any reason by the government sector employee or public sector employee. Whereas in case of the private sector, for any extra leave, the money or amount is deducted from the salary. So this type of binary, what is created, that is the principal challenge of Article 39C, because we know that every worker, whether it is public sector or private sector, all are working for the welfare of the state. What is the present scenario? State, for the achievement of the purpose or for the development of the state, both sector has the equal value. So their contribution of the workers, but whether on one sector there is the job security and facilities, and in other sector there is the complete deprivation, whereas they both are doing for the nation. So that is the principal challenge of Article 39C. That's why thirdly, that scope of negligence or avoidance of discharging the official duty or shirking the responsibility, official responsibility, that is the principal challenge. And fourthly, that is the job security. You know that for public sector employee, once somehow anybody can secure the job, even by the political concoction or by giving the bribery. That means by getting the job, by providing the huge bribery amounts or bribes, or by the political nexus, and thereby there is a tendency to not to perform the official duty, rather to participate in the trade union meeting or bandh, strike, etc., and as a result public suffer. Whereas there is no such scope in case of private sector employee, and there is the force, at least in case of the bandh or strike, they must be present in the office, that is the declaration. If they are not present, then there can be the show cause. So that means there is the lack of security, and moreover in most of the cases, even the employer never provide them the appointment letter. That means everything they are doing at the mercy of the employer. So that is the present scenario even after the independence. So whether this is the sign of the independence or whether this is a new form of the slavery, that is the question to be raised nowadays. Now I would like to visualize about the consequential effect of violation of Article 39 Clause C upon the various fundamental rights enshrined in our Constitution. First, Article 14, that is right to equality. It is absurd thing. Because of this binary creation between the scope of public sector employee or government sector employee and the private sector employee, it is absolutely impossible when there is the too much inequality of income irrationally. So how that equality end, which is etymologically written in Constitution, can at all be achieved? Second is Article 19, that is says about freedom of speech and expression. If any employee's job is not secure at all, how can we expect the freedom of speech from that person? So in case of public sector employee, if any worker, even he commits the crime, trade union stands behind him and he escapes the liability of law though he has committed the crime, and even the innocent public are suffering because of the instance of the political party. Whereas in case of the private sector employee, even the innocent employee can be terminated from the service without any reason at the whim of the employer. So how can we expect the freedom of speech and expression as enshrined in our Constitution from the private sector employee? It is another absurd thing. Next I am coming to Article 21, which says that the right to life and liberty. So right to life and liberty without the proper money, how that is possible? It is also absurd thing. So right to life and liberty, which can be available only for the public sector or government sector employee, and for other sectors and for the private sector or for other small traders, etc., they have what appears to be they have the right to die only, not to survive, in the present scenario at least. And next, that is Article 21A. Though we know that in our Constitution it is stated in Article 21A that free and compulsory education to all children, it is written over there. To all children means whether it is only for for public sector or government sector employee. Whereas in case of the small traders or private sector employee, that is absurd thing, because they cannot meet their both ends they meet. And so how the education will be properly channelized? Because nowadays education means not only the books and the exercise book or etc. There is the requirement of a laptop or a good mobile, iPhone, etc. So that can be availed only by the children of the government sector or public sector employee who are getting the fabulous salary and along with the other facilities. But whereas in case of the private sector employee, that is beyond any imagination. So that's why Article 21A, what is enshrined, it is also cannot be followed. Mere signing the paper, that is not the true education. We have to remember that what Swami Vivekananda states, that we want that education by which character is formed, strength of mind is expanded, and by which ultimately one man can stand on his own feet. So we want that education. So that is not possible because of this binary created by the state, because of the lack of enforcement of Article 39C. So we have to think over about this new challenge. Now I would like to discuss about the consequential effect of violation of Article 39C upon the other directive principles of state policy. First of all, I would like to discuss about Article 38. We know that the object of Article 38 as enshrined is that states shall strive to promote welfare of the people and try to minimize the inequalities of income, status, facilities, opportunities amongst the people. But it appears to be like penny wise, pound foolish, because of this practical binary creation, that is absurd thing which cannot be achieved at all. Second is Article 39, what states about that as a whole, that means Article 39 is as a whole violated because there is the existence scenario of division between public and private sector employees, and as a result equality, adequate means of livelihood, distribution of material resources, it is as enshrined in our constitution, is impossible to achieve. And third is Article 47, which states that state will raise the nutrition level of nutrition or standard of living. That is also not possible if the economic strata is increased among the all classes of the people. Now I would like to discuss in brief about two judgments given by our apex court which are relevant to this context. First is State of Tamil Nadu versus Abu Kabir Bhai. So State of Tamil Nadu versus Abu Kabir Bhai, it was observed by Supreme Court that a nationalization scheme meant for the purpose of distribution or preventing the concentration of wealth. So court is emphasizing upon distribution and also preventing the concentration of wealth. And second decision, that is Assam Similiate Limited versus Union of India. So in Assam Similiate Limited versus Union of India, Supreme Court interpreted the term distribution so as to include nationalization of private enterprise and provision for service through the state. So service through the state was emphasized in this decision. Now I am coming to the solution of this problem, that how that problem can be solved. I think that there is the only way in the present scenario, though it is very difficult to achieve but is not impossible, that is either complete nationalization or complete privatization. So either by introduction of one job pattern, that is total nationalization or total privatization, then only it may stop the irrational binary creation. So if that end is achieved by the state, that means either introduction of the complete nationalization or privatization, then state must run for the achievement of the end enshrined in Article 39 Clause C, and then state must try to prevent the infinitive corruption which is prevailing in our country. Then only that problem can be solved. Last of all, I would like to say that India is trying to achieve the welfare state. That means our motto is to obtain the welfare state status. But in order to do that, that binary creation must be stopped. Only either the introduction of the thorough nationalization or privatization, as the case may be, that problem only can be solved, because we know what is the present society or scenario for arrangement of marriage. Everywhere there is one question raised, that whether the bridegroom is the government employee or public sector employee. If he is of any private sector employee, his marriage will not be there. So what does it mean? That it is the sense that private sector job workers are not competent even for the marriage. That means they are inferior in the society. So how that concept will develop our welfare pattern of the state? So that is the most crucial challenge in this present scenario. Some of may say that in private sector also, in various private sector job, a very fabulous salary is being offered, but question is how much person are getting that opportunity? Only it is concentrated to a few section of the people, but interest of the nation cannot be dependent on a narrow percentage of the people. Unless the facility is provided to maximum or major portion, or even possible for the all sections of the people, then that cannot be achieved. So that's why that binary creation, if it is stopped either by this process, then only that achievement of that goal, pious goal, which is enshrined in our Article 39C, can be achieved by the state.